School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 4 Legal and Regulatory Framework for Financing and Investments of Business. Unit 9 Insolvency and Bankruptcy. Part 1.
After completing this unit, you should be able to understand the basics of insolvency law and practice, describe the legal and regulatory system relating to distress or insolvency resolution in India prior to the enactment of the IBC, explain the essential segments of the corporate insolvency under the Insolvency and Bankruptcy Code 2016, and discuss different aspects relating to individual bankruptcy and liquidation of insolvent companies. Introduction. This unit explains the law and mechanism related to corporate insolvency resolution process for corporates in India. The unit commences describing the legal and regulatory situation in place prior to enacting of the Insolvency and Bankruptcy Code 2016. It further examines the need to adopt the Insolvency and Bankruptcy Code 2016, hereinafter referred to as IBC or the Code. It discusses the salient aspects of the Code with the help of leading cases. An effective and efficient insolvency regime should aim to achieve the key objectives which are identified in a balanced manner. These objectives are: Number 1. Provide certainty in the market to promote economic stability and growth. Number 2. Maximize value of assets. Number 3. Strike a balance between liquidation and reorganization. Number 4. Ensure equitable treatment of similarly situated creditors. And number 5. Provide for timely, efficient, and impartial resolution of insolvency. Definition of insolvency. The United Nations Commission on International Trade Law, that is UNCITRAL, Legislative Guide on Insolvency Law defines insolvency as, and I quote, "Insolvency is when a debtor is generally unable to pay its debts as they mature or when its liabilities exceed the value of its assets," unquote. In the context of the UK Insolvency Act 1986, the renowned author Sir Roy Good observed, and I quote, "A company is insolvent when it is unable to pay its debts. The concept is simple enough, but as we shall see, there is more than one test of inability to pay debts, and in marginal cases, it may be far from easy to determine whether the test is satisfied as at the relevant time. Insolvency as such is not a condition to which legal consequences attach. These occur only after there has been some formal proceeding, such as winding up or the appointment of an administrator or administrative receiver. Thus, it is neither a criminal offense nor a civil wrong for a company to become insolvent or even to trade while insolvent," unquote. The Oxford Dictionary defines word insolvent as, and I quote, "not having enough money to pay debt, creditors, etc., belonging or relating to insolvent people, or the stale of being insolvent," unquote. Surprisingly, unlike the international laws, the code does not define insolvency in explicit terms. However, default by the corporate debtor has been marked as a trigger for initiating the insolvency proceedings. The Bankruptcy Law Reform Committee report, that is BLRC report, explains insolvency in these terms. These terms are: number 1, financial failure. A persistent mismatch between payments by the enterprise and receivables into the enterprise, even though the business model is generating revenues. And number 2, business failure. This is a breakdown in the business model of the enterprise and it is unable to generate sufficient revenues to meet payments. Corporate insolvency legislative framework in India prior to 2016. India had a patchwork of insolvency courts and tribunals applying to different classes of stakeholders or processes, which resulted in parallel proceedings, conflicts between different statutes, and uncertainty for creditors over their recovery. The conflicts and multiple proceedings that have arisen from the multi-layered insolvency law framework pointed towards a strong need for a unified bankruptcy code that could be applicable to all aspects of a company in distress and for all stakeholders. The complex web of laws which till recent past governed corporate bankruptcy and insolvency included: number 1, Companies Act 2013, that is CA 2013. This act contains provisions on collective insolvency resolution by way of restructuring, rehabilitation, or reorganization of entities registered under the act. Adjudication authority is the National Company Law Tribunal, that is NCLT. CA 2013 contains provisions for rescue and rehabilitation of all registered entities in Chapter 19 and liquidation in Chapter 20. Number 2, Companies Act 1956, that is CA 1956. This legislation deals with winding up of companies. There is, however, no separate provisions for restructuring except through mergers and acquisitions, that is M&As, and voluntary compromise. Adjudication authority is the High Court. Number 3, Sikh Industrial Companies Act 1985, that is SICA 1985. This act dealt with restructuring of distressed industrial firms. Under this act, the Board for Industrial and Financial Reconstruction, that is BIFR, assessed the viability of the industrial company and referred an unviable company to the High Court for liquidation. SICA 1985 contained special provisions for timely detection of sick industrial companies and for undertaking preventive, ameliorative, remedial and other measures in respect of such companies. Number 4, the Recovery of Debt Due to Banks and Financial Institutions Act 1993, that is RDDBFIA 1993. This act gives banks and specified set of financial institutions greater powers to recover collateral at default. The law provides for the establishment of special debt recovery tribunals, that is DRTs, to enforce debt recovery by these institutions only. The law also provides for the debt recovery appellate tribunals, that is DRATs, as the appellate forum. And number 5, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, that is SARFAESI 2002. This act enables secured creditors to take possession of collateral without requiring the involvement of a court or tribunal. This law provides for actions by secured creditors to take precedence over a reference by a debtor to BIFR. The DRT is the forum for appeals against such recovery. Issues relating to various legislations dealing with corporate insolvency and restructuring. SICA. Under the SICA, industrial companies whose net worth has eroded by 100% are identified as being in distress and are referred to the BIFR. Thereafter, the BIFR must investigate the potential viability of the industrial company and then either recommend its rehabilitation scheme or winding up before the High Court. Major issues with the legislation are: number 1, delay. Under SICA provisions, 5 to 7 years are required for reviving a company, out of which around 3 to 4 years are required just to decide whether a particular company needs rehabilitation or liquidation. Delays further contribute to other issues such as debtors using the delay to defer payments to the creditors because of the moratorium that is placed upon creditor enforcement, corporate assets being siphoned off during the long drawn process, managers coercing creditors into extending further finance or giving concessions in existing debts. It has been observed that SICA is capable of achieving a swift liquidation only where creditors rejected possibility of revival. Number 2, improper identification of companies that can be restructured. It has been repeatedly stated that the BIFR has failed to satisfactorily identify companies capable of restructuring or have sanctioned schemes which have severely hampered the creditor's interest. Number 3. SICA does not assess the creditor. In many cases where the creditors seek liquidation, the cases have been sent back to the BIFR to conduct inquiry into rehabilitation. Then comes SARFAESI. This act provides mechanism to the secured creditor to take possession of the property of the debtor without intervention by the courts or tribunals. Appeals against such possession may be made to the DRT. And last is RDDBFI. This act focuses specifically on the easing recovery for banks and other financial institutions, both secured and unsecured creditors. The Act additionally provided for the establishment of DRTs and DRATs. Unified Insolvency and Bankruptcy Law, the Insolvency and Bankruptcy Code 2016. As mentioned so far, a host of legislation and forum combined with potentially conflicting jurisdictional issues had resulted in systemic delays and complexities in the insolvency and bankruptcy process. Additionally, all these legislations have been identified as being inadequate in by themselves. Thus, the Insolvency and Bankruptcy Code 2016, hereinafter referred to as IBC or the Code, was enacted. This code aims to consolidate the laws relating to insolvency of companies and limited liability entities, including limited liability partnerships and other entities with limited liability, unlimited liability partnerships, and individuals presently contained in a number of legislations into a single legislation. Such consolidation will provide for a greater clarity in law and facilitate the application of consistent and coherent provisions to different stakeholders affected by business failure or inability to pay debt. An effective insolvency regime is a critical component of ease of doing business in India. This code is considered as the biggest economic reform next only to GST. The insolvency regime is expected not only to facilitate an easy revival and rehabilitation process for companies in financial trouble, but also to be very effective in safeguarding the interests of the stakeholders such as creditors, shareholders, government, etc. It is also expected to stabilize the commercial dealings financial stability, and better environment for attracting investments besides mitigation of corporate failures. Further, it should also ensure that the financial resources of a country are utilized efficiently to enhance the overall growth of the economy. Salient features of IBC 2016. The salient features of the IBC 2016 are: number 1, clear, coherent, and speedy process for early identification of financial distress and resolution of companies and limited liability entities if the underlying business is found to be viable. Number 2, two distinct processes for resolution of individuals, namely fresh start and insolvency resolution. Number 3, Debt Recovery Tribunal and National Company Law Tribunal to act as adjudicating authority and deal with the cases related to insolvency, liquidation, and bankruptcy process in respect of individuals and unlimited partnership firms, and in respect of companies and limited liability entities, respectively. Number 4, establishment of an Insolvency and Bankruptcy Board of India to exercise regulatory oversight over insolvency professionals, insolvency professional agencies, and information utilities. Number 5, insolvency professionals would handle the commercial aspects of insolvency resolution process. Insolvency professional agencies will develop professional standards, code of ethics, and be first level regulator for insolvency professionals, leading to development of a competitive industry for such professionals. Number 6, information utilities would collect, collate, authenticate, and disseminate financial information to be used in insolvency, liquidation, and bankruptcy proceedings. And number 7, enabling provisions to deal with cross-border insolvency. Four pillars of institutional infrastructure under IBC 2016. There exist four pillars of institutional infrastructure created by the IBC 2016. These are: number 1, insolvency professionals and insolvency professional agencies. The first pillar of institutional infrastructure is a class of regulated persons, the insolvency professionals. They play a key role in the efficient working of the bankruptcy process and are regulated by insolvency professional agencies. An insolvency professional, that is IP, plays a central role in the effective and efficient implementation of an insolvency law with certain powers over debtors and their assets and a duty to protect those assets and their value as well as the interests of creditors and employees, and to ensure that the law is applied effectively and impartially. An IP may hold different roles under the code. These roles are: number 1, resolution professional or RP, which is to resolve insolvency for a firm or an individual. Number 2, bankruptcy trustee in an individual bankruptcy process. And number 3, liquidator in a firm liquidation process. Who can be insolvency professional under IBC 2016? Regulation 5 of the Insolvency and Bankruptcy Board of India, that is Insolvency Professionals Regulations 2016, provides certain qualifications and experience to become an insolvency professional. Subject to the other provisions of these regulations, an individual shall be eligible for registration if he has passed the National Insolvency Examination. Also, if he has passed the Limited Insolvency Examination and has 15 years of experience in management after he received a bachelor's degree from a university established or recognized by law, or he has passed the Limited Insolvency Examination and has 10 years of experience as a chartered accountant enrolled as a member of Institute of Chartered Accountants of India, or a company secretary enrolled as a member of Institute of Company Secretaries of India, or a cost accountant enrolled as a member of the Institute of Cost and Works Accountants of India, or an advocate enrolled with a bar council. Then comes information utilities. The second pillar of institutional infrastructure is a new industry of information utilities. These are service providers which are required to store facts about lenders and terms of lending in electronic databases. This is intended to eliminate delays and disputes about facts when default takes place. Chapter 5 of Part 4 of the IBC contains provisions with respect to information utilities. An information utility is contemplated as a registered service provider which shall be obliged to: number 1. Create and store financial information in a universally accessible format. Number 2. Accept electronic submissions of financial information from persons who are under obligations to submit financial information under the code in such form and manner as may be specified by regulations. Number 3. Accept in specified form and manner electronic submissions of financial information from persons who intend to submit such information. Number 4. Meet such minimum service quality standards as may be specified by regulations. Number 5. Get the information received from various persons authenticated by all concerned parties before storing such information. Number 6. Provide access to the financial information stored by it to any person who intends to access such information in such manner as may be specified by regulations. Number 7. Publish such statistical information as may be specified by regulations. And number 8. Have interoperability with other information utilities. Any person who intends to submit financial information to the information utility or access the information from the information utility shall pay such fee and submit information in such form and manner as may be specified by regulations. Next point is adjudication. The third pillar of institutional infrastructure is the adjudication authorities. The National Company Law Tribunal, that is NCLT, is the forum where insolvency of corporate persons will be heard, and DRT is the forum where individual insolvencies will be heard. These institutions, along with their appellate bodies, viz. NCLAT and DRATs, will be adequately strengthened so as to achieve world-class functioning of the bankruptcy process. Adjudicator for Corporate Insolvency and Bankruptcy, National Company Law Tribunal. The adjudicating authority in relation to insolvency resolution and liquidation for corporate persons, including corporate debtors and personal guarantors thereof, shall be the National Company Law Tribunal. Territorial jurisdiction. The NCLT will have territorial jurisdiction over the place where the registered office of the corporate person is located. The NCLT, before which a corporate insolvency resolution process or liquidation proceeding of a corporate debtor is pending, will also have jurisdiction in the matter of the insolvency resolution or bankruptcy of a personal guarantor of such corporate debtor. An insolvency resolution process or bankruptcy proceeding of a personal guarantor of the corporate debtor pending in any court or tribunal shall stand transferred to the NCLT dealing with insolvency resolution process or liquidation proceeding of such corporate debtor. The NCLT is vested with all the powers of the Debt Recovery Tribunal and shall have jurisdiction to entertain or dispose of: number 1. Any application or proceeding by or against the corporate debtor or corporate person. Number 2. Any claim made by or against the corporate debtor or corporate person, including claims by or against any of its subsidiaries situated in India. And number 3. Any question of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceedings of the corporate debtor or corporate person under the code. Civil court not to have jurisdiction. No civil court or authority has jurisdiction to entertain any suit or proceedings in respect of any matter on which NCLT or the National Company Law Appellate Tribunal has jurisdiction under this code. No court, tribunal, or authority shall grant an injunction in respect of any action taken or to be taken in pursuance of any power conferred on the NCLT or the National Company Law Appellate Tribunal under the code. Adjudicator for insolvency resolution and bankruptcy of individuals and partnerships, that is, Debt Recovery Tribunal or DRT. The adjudicating authority in relation to insolvency matters of individuals and firms shall be the Debt Recovery Tribunal, having territorial jurisdiction over the place where the individual debtor actually and voluntarily resides or carries on business or personally works for gain, and can entertain an application under this code regarding such person. The Debt Recovery Tribunal shall have jurisdiction to enter or dispose of: number 1. Any suit or proceeding by or against the individual debtor. Number 2. Any claim made by or against the individual debtor. And number 3. Any question of priorities or any other question, whether of law or facts, arising out of or in relation to insolvency and bankruptcy of the individual debtor or firm under this code. An appeal from an order of the Debt Recovery Tribunal under this code shall be filed within 30 days before the Debt Recovery Appellate Tribunal, that is DRAT. An appeal from an order of the Debt Recovery Appellate Tribunal on a question of law under this code shall be filed within 45 days before the Supreme Court. Last is the Insolvency and Bankruptcy Board of India, that is IBBI. The fourth pillar of institutional infrastructure is the regulator, the Insolvency and Bankruptcy Board of India, hereinafter referred to as the Board or IBBI. It has its head office in the National Capital Region and offices at other places in India as well. The central government has the power to designate a financial sector regulator to perform the functions till such time the board is constituted. Until the board is constituted or a financial sector regulator is designated under Section 195, as the case may be, the powers and functions of the board or such designated financial sector regulator, including its power to make regulations, shall be exercised by the central government. Constitution of Board and selection of members. The board shall consist of the members to be appointed by the central government, who shall appoint them other than the ex officio members after obtaining the recommendation of a selection committee. The board consists of: number 1. Chairperson. Number 2. 3 ex officio members from amongst the officers of the central government, not below the rank of Joint Secretary or equivalent, 1 each to represent the Ministry of Finance, the Ministry of Corporate Affairs, and the Ministry of Law. Number 3. 1 ex officio member to be nominated by the Reserve Bank of India. And number 4. 5 other members to be nominated by the central government, of whom at least 3 shall be the whole-time members. The tenure of the office bearers is given in Section 189, Clause 4 of the IBC 2016. The term of office of all the members except ex-office members shall be for a period of 5 years or until they attain the age of 65, whichever is earlier. They are eligible for reappointment as well. Objectives of the board. The objective of the board is to utilize all legislative, executive, and quasi-judicial functions so as to achieve a well-functioning bankruptcy process in India. This would include features of: number 1, high recovery rates in an NPV sense. Number 2, low delays from start to end. Number 3, sound coverage of the widest possible class of claims, for example, bank loans, corporate bonds, etc. And number 4, a perception in the minds of persons in the economy that India has a swift and competent bankruptcy process.
We were listening to the audiobook by the School of Management Studies, IGNOU, for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.